Hello, everyone. You have entered the webinar as a mute attendee, but Zoom features include a Q&A tab where you can ask any questions during the program. We'll collect them all and answer either live during the webinar or after by email. And if you want to download our fact pattern, it's available in the chat right now. And now, after a brief introduction, we'll proceed with today's webinar. As always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. Bo?
Thank you, Kathy. Good afternoon, everyone, and welcome. Thank you for joining today's webinar focusing on the complexities of trucking mediations. We're fortunate to have an experienced panel of attorneys and a mediator who regularly work on transportation and trucking matters. They bring perspectives from both litigation and dispute resolution. And today, they'll be sharing their thoughts and insights on handling trucking related cases. Rather than reading biographies, I'm going to invite each of the panelists to provide a little background of their work in the trucking field and cases. And I'll start with my background. My name is Bo Johnson. I'm a Florida Supreme Court certified circuit court mediator. I've been with the Upchurch, Watson, White, and Max mediation group for approximately 2 years. I'm a former prosecutor who tried over 100 jury trials as a prosecutor. I later became a firm partner handling both plaintiff and defense cases involving PI and wrongful death litigation, including trucking cases. Joe, if you would please provide us with your background in trucking cases.
Sure. My name is Joe Camerlengo. I'm the founding member of the Truck Accident Law Firm along with Joe Freed. We handle almost exclusively tractor trailer crashes all over the country. Been doing that focused on trucking since 2008 and exclusively since 2014. Board certified. I was telling Dan about this just the other day. There's actually a national ABA accredited certification in trucking, and I'm a board certified trucking lawyer as well as civil trial. Happy to be here. Thanks for the invite.
Thank you. Dan?
Hey guys, I'm on the defense side. So many of you probably know me. I have 200 plus attorneys in the state of Florida. We have a dedicated practice group that does trucking and transportation. I've had the pleasure of trying trucking cases against the Camerlengo firm, Joe Freed. They're great guys, but very good trucking lawyers. And we handle a lot of big exposure cases, either as primary defense counsel or as excess monitoring counsel. So glad to be here.
Thank you. Mr. Marion.
Yes, sir. My name is John Marion. I have practiced law for over 40 years in the state of Florida, 38 years of which I was a founding partner of a law firm that I did mainly defense work, but some plaintiffs work. I handled a lot of catastrophic injury cases and trucking cases, dealt with a lot of coverage issues in my practice, and so I understand the complexities of the issues that are involved in trucking accident cases. I've been a mediator for the last almost 7 years. I'm one of the principals at the Upchurch, Watson, White, and Max mediation firm. And so we're here today to talk about those complex issues in the trucking industry.
Thank you. During today's webinar, we're going to walk through a hypothetical trucking accident case, which was provided to you all before today's webinar, and I believe it's going to be in the chat room. And we're going to use that, and I'm going to direct and ask Mr. Marion, as a mediator, how would you handle the hypothetical trucking accident case with the attorneys at a mediation?
So there's a lot of things that come into play when you mediate one of these cases, mainly coverage issues, broker issues and this fact pattern. I want Joe to talk about the fact pattern for a few moments, and then after he's talked about it, then I'm going to talk to you about what needs to be done in advance. I'm going to ask the panel members, Joseph first, and then Daniel, what they do to get ready for a complex trucking case mediation. And then I'm going to talk about what I do to facilitate the success of a mediation, what I do beforehand. So, Joe, talk to us a little bit about the facts, if you will, and then we'll move into discussions.
Sure. Thanks, John. We all kind of put this one together based on typical things we see. We wanted to have a fact pattern that, challenge both liability, damage, and coverage issues. So here we have a passenger car, a Nissan Altima, running into the rear of a slower moving, fully loaded tractor trailer, 3:30 in the morning on the interstate, on a dark, rural, flat, long, straight stretch of highway. 2 lanes. The car was doing 79 in the 70s, so you have speeding issues on the part of the car. The driver of the tractor trailer says under oath at the scene he's traveling 60 miles an hour in the right lane and is rear-ended without warning. He also claims he never saw the car approaching and thinks maybe the headlights weren't on. The physical evidence shows that the Nissan swerves at the last second, so there is some evasive action taken. The download of the tractor trailer shows, as well as the dash cam and GPS, that it was actually going 25 miles an hour in the right lane and had recently pulled off the interstate and it was just getting back onto the interstate, not up to speed yet. So you have some complicating issues of liability on both sides. In the passenger vehicle, there is a driver and a passenger. The passenger is killed instantly. Driver suffers what they contend is significant injuries. The trucking company, XYZ Trucking, is a medium-sized trucking company with no safety rating. However, they're quickly available published stats from the Safer Sys, the Federal Motor Carrier Safety Administration, shows higher than average out-of-service percentages for vehicle maintenance, as well as a number of critical violations and crashes in the last 24 months. So you have a negligent selection and agency theories against ABC Broker for hiring XYZ Trucking. And then you have some coverage complexities. The trucking company has $1 million underlying, then a 4 and a 5 excess policies for a total of 10. And ABC Broker has a $5 million initial policy and then 3 $25 million excess layers to get to a total of 80 cases on basically close to trial, motions in limine and summary judgments pending. Not likely that the court is going to rule on any of that before trial. So it's contested on all grounds: liability, damages, and insurance coverage.
Okay, thank you for the fact pattern, Joe. What do you do in a case like this to get yourself ready for a successful mediation?
Well, I mean, for me, the first thing that you want to do, hopefully, this far into the case, you've established a good working relationship with defense counsel, and you're speaking either directly or providing information through to the excess carriers so that you're making sure that they're informed, right? The defense is claiming, it's a modified contrimmed state. If they prove 51%, no recovery for the driver. Plaintiff's recovery of the passenger is substantially limited. So they're thinking they could keep it if their best day in that first layer, inside the trucking company's 10, I should say, right? The plaintiff is thinking that's not going to happen. We've got some aggravated liability facts. We're believing each one of these cases has multiple, significant 8-figure value, and that the jury is going to be mad at the defendant. So it's a long, straight, rural road. So we'd show that, looming here, there's no visual cues without hazards on or some other warning that the truck was going. This was an unavoidable crash, and that the truck driver created the hazard. And of course, the bad truck driver and company on the road goes back to ABC Trucking, right? Or ABC Broker. So for me, I want to go in and have communications ahead of time. I want to know who the excess layers are. And I'm going to try and confirm before we ever get to this point that long ago the trucking money should be in. So for purposes of my negotiations, trucking 10's got to already be on the table, and where, maybe not formally, but we know that we're talking with the ABC brokers, insurance layers, and we would want to be basically talking to the top 2 layers to say, if you all will work with us, we'll make sure this stays underneath your layers, depending on the case and the clientele and the economics and where the clients are, so that we have some downward pressure coming from the excess carriers, knowing that if we try the case and we get the verdict that we think we're going to get, that we'd be, that we could exceed all layers of coverage when you add up these two catastrophic injury cases.
Okay. And so ahead of that, you're going to have conversations in this scenario with Dan.
Absolutely.
You're going to also want the excess carriers involved.
Yeah, I mean, Dan and I work. I'm very fortunate whenever we get to work with Dan. He's one of the best truck, if not certainly the best defense lawyer we've ever seen at trial, and we've seen a lot. And I don't mean that lightly, and not just because he's here. Joe Freed or I would say that in a heartbeat. So and we have a great relationship. So with when we have a lawyer on like Dan and I that have gone against each other, and knows like he's a badass, can win this case, and he knows I'm a good lawyer and I could do really well, maybe even a 9-figure verdict in this one we'd be asking for. So in that scenario, we have mutual respect and understanding of the risks. I want to know who's calling the shots. Now, Dan may not be at liberty to tell me, so I would like to be able to have a lawyer I can trust on the other side to have kind of frank discussions of where we think we can get our clients. Can they get even in the same, not even zip code? I mean, are we in the same ballpark? Are we in the same stratosphere, or are we too high, too low, et cetera?
So it helps you to make sure through Dan that he's going to have the appropriate layers of coverage attending the mediation.
Absolutely. And sometimes when we don't get that cooperation, we're going to reach out directly to the excess carriers, right? The frontline defense lawyer does not have an attorney-client relationship with anybody other than the defendants and the carrier that hired them. And so we wouldn't call their carrier, but the carriers above that, if they're refusing to let us talk to them or give us that information, we'll reach out directly to just try and find out who we're dealing with and make sure that they're getting copied and that they're, if the frontline lawyer, whoever's the main defense lawyer, is not providing that information to us and copying them, then I'm worried they're not being informed, John, and they're not being up to date. They're not appraising it. They haven't put reserves on it, those type of things where we can even get to them.
So from your perspective, in order to have a successful mediation, these things have to be done ahead of time.
Yeah, just mutual disclosure, mutual, honest discussions about where everybody is. And conversely, I want to ask Dan, what do you not have that I can get you? Is there anything you need that will help on your side to get the reserves where we both think this case could be in the ballpark of where then the mediators can get it done?
Okay. So Dan, your turn. When you're getting ready to mediate a complex trucking case like this one, like this fact pattern, what do you do ahead of mediation to make sure that you're in the best possible position to succeed?
So let me start with this. What is the purpose of mediation? The purpose of mediation is, the primary purpose may be to settle the case. The secondary purpose may be to figure out what it would take to settle the case. Now, I look at cases like there's a want number, this is what they want. There's a take number, this is what I think they'll take. And then there's a break number, and that's a number that is going to settle the case. So I need to know a couple of things going in. Number one, anybody on this call needs to understand that these are complicated mediations. If you think you can treat these like regular accident cases and just show up, you're wrong. Unless it's a combined single limit one and you're there with a box of chocolates in your check. But these are complex cases. So first of all, you got to figure out, what's my role in this mediation? Am I primary defense counsel? Did the primary insurer hire for me? Am I in the Tower of Terror somewhere? Am I 5x1? Am I 10x50? Is my named insured the motor carrier, meaning the owner of the power unit, or the company that was hired to do the shipping? Or is my named insured the shipper that hired the driver as an independent contractor? Or is my named insured the broker who thinks that the ostrich will survive in Florida when the ostrich always gets its neck cut off? So I need to know where I am and who I'm representing, and then I need to get to figure out, who's on first and who's going to have the money. So what I always try to do is a couple of things. One, you got to communicate with plaintiff counsel. Now, if we've got some adversaries on here that don't communicate, that's fine. But here's my pitch to you. I wear two hats in my life, a settlement hat and a trial hat. And if you're not going to take advantage to talk to me when I wear my settlement hat, then you're only going to see the trial hat. So I want to have a good communication. I don't want you to bid against yourself, but I kind of want to know if we're dressing up for the game and the game is mediation, are we in the same ballpark? Are we in the same arena? Are we in the same city? Are we in different states when it comes to liability and damages? So I've got to kind of have that talk with plaintiff. But the other thing I need to do is I want a fruitful mediation. So to me, there has to be a pre-mediation tower call set up where all the insurers get together and kind of talk. If there are coverage problems, horizontal exhaustion before we kick in, or no, we're really not pro rata, we're really excess to total exhaustion. I need to iron those things out long before I get in that mediation, because I don't want to spend the first 3 hours on those issues pissing off the other side. So that's what I'm trying to do. And then, of course, your insured should be involved in those calls too, because your insured's wishes are important. So that's how I'm trying to set it up. I want to know how the coverage lines up. And I'm not saying I'm the coverage lawyer. And people say, oh, we can't discuss coverage with you. Yes, you friggin' can. And I expect to know it if I'm going to get my job done in a mediation. I want to know how the coverages line up, who's up to bat, and what the bullpen looks like. And that's critical for me. And then we figure out how to skin the cat with Joe's numbers.
Okay. And in such a situation, Dan, where you only represent the motor vehicle carrier, not the broker, is there also a pre-mediation effort on your part to talk with a lawyer for the broker?
There's got to be, John.
Yeah.
I mean, I need to know what everyone's doing. And sometimes the broker, if I represent motor carrier and we only got a combined single limit of $1 million, no excess, and I'm going to have problems because who do I get on my release if I tender up that number? Am I going to get the broker on the release? Joe C is going to say, hell no. Am I going to get a partial release for the broker? Are there any other additional insureds that I need to protect? Because remember, there's always two roads to Rome on these cases. Road number one is, what is your client, the insured's obligation to others resulting from this accident? Road number two is, what is the insurance company's obligation to others arising from this accident? So I need to know, I want to get a call with the broker. If they're going to play it tight, or, excess is going to play it tight, then at least I tried to bring the people together. And I've been in that situation. And that's when I come in and tell Rod Max, save your breath because my money's up and I can't help you on anything else. But yeah, you really want to, when we worry about nuclear verdicts, we're seeing nuclear verdicts on certain types of cases. It's not on slip and falls. It's not on personal line motor vehicle accident cases. It's on trucking. It's on reptile cases. Trucking is number one where we're seeing that. And to some extent on negligent security cases, but we're on trucking today. So you're dealing with this type of case, you need to do the work on a mediation, because on what percentage of cases settle? 98%. So why would you spend all your effort on the 2%? You need to spend it on the 98%.
And so if you need the mediator to jump in ahead of time and mediate the issues between the defendants, do you call on that card?
So I'm a certified mediator and I feel like I can get it done without, rubbing egos the wrong way. But yeah, I've done it. I've gone to you guys and said, listen, we got a coverage fiasco. Everybody's hiding behind their coverage lawyers that have never seen the inside of a courtroom. Sorry, guys, but we need to mediate this issue separately, and then let's get to the plaintiff. And I've done that, particularly not just trucking. You're going to do that on a complex construction CD case as well. John Marion, you've been in that situation with me. So sometimes it's done, but I got to tell you, on our side of the house, people don't want to be told that they need a mediator on how to play in the defense sandbox. They think they can do it on their own. But until you get everyone talking, you're never going to know what everyone's doing.
Right. And that often happens the day of mediation and leaves Joe sitting there waiting for an answer for hours and hours and hours. And so, at least from my perspective, so I'll speak now about the mediator's perspective. I reach out ahead of time and ask the lawyers how I can help ahead of time. I talk to them about the facts of the case ahead of time. If there are coverage issues, I offer to mediate those issues ahead of time, because it's only once you have some reasonable understanding of who's going to pay and how that you have an opportunity to reasonably get the case resolved. Because if everybody stands on principle, there's nothing that can happen. For example, in this case with XYZ Trucking, they've got $1 million underlying, a 4 on top of that, and a 5 on top of that. If the $1 million carrier is saying we got a coverage defense, then the excess carriers are going to line up behind them, right? So one of the issues that comes up in these kinds of cases is the MCS 90 endorsement that requires the carrier to pay after the fact. And so there's leverage there. You can say, look, you can go through trial, you can get a judgment against XYZ, you can figure out whether you're going to win or lose the coverage issue at that point in time, or you can do away with all that risk, because if you're wrong then, it's really bad. You can do away with all that risk now by getting involved in the settlement, maybe offering your limits and get the excess carriers involved too. So there's a lot that can be done ahead of time. I think you're wise to mediate it yourself, Dan, if you can. And I know you're bright and can do that on your own. But if you don't feel comfortable doing it, other defense lawyers that handle these cases may not feel comfortable mediating those issues on their own. The mediator can and should get involved.
And I agree with that to some extent, John, because we really don't understand coverage like the coverage people do. But the
Yeah.
problem is like 90% of the time I go into these, when you really grab the coverage people and say, just spit it out. What's your real coverage defense? There's never anything really good there. So, but I agree with you.
So if you can push that button and you can get somebody to understand, even if you feel strongly about your coverage defense, after the verdict, you're going to have to pay it. Then you're going to have to chase your own insured who probably doesn't have any money to pay you back. That maybe sometimes breaks the logjam. In the broker scenario that we have here, let's talk a little bit about that issue. We have
John, can I just add one thing from the plaintiff's
yes,
perspective?
please.
And Dan said a lot of great things there. One is, these cases can't be approached settlement or mediation like even a normal big, for the same injury, car wreck or whatever you want to call it. 1000% correct. I think it also helps on the plaintiff side when the mediator gets involved early to start having those discussions with us and making us go meet with our clients and providing some of the defense perspective. And some mediators want to actually meet with and talk to the clients ahead of time. And I know that's hard as busy as you all are. But if you're making us get our ducks in a row on our side, we have multiple claimants here. There's probably multiple lawyers. Could be a potential conflict. And then on the defense side, doing the same thing, it's going to make for a more meaningful mediation when you get there, times 1,000. We've
Yes,
had
that's
cases
right.
where my clients would have settled for, I can think of an exact case, $10 million, and the two defendants were aligned, but their carriers didn't have the discussion ahead of time. Rod mediated the case. I don't say which one it is, and they would not agree to pay the money, and we wound up settling the case for almost 15 because then we separated them and we negotiated with each of them separately and made it a condition they couldn't talk to each other as to who was paying what. And we wound up getting almost $15 million within 3 weeks, right? Because everybody's scared of going to trial and being the last one holding the bag. When if they just had gotten their ducks in a row before we got there, the case would have settled for 10 and everybody would have been happy.
Yeah. Well, so I was going to get there, and that's part of our discussion today is the mediator, from my perspective, needs to be in touch with both parties ahead of time, talk to them about the facts of the case, sometimes meet with the plaintiffs if that's appropriate. And Joe, if I reached out to you, you'd let me know if that was appropriate. you'd let me know if that was something that would be helpful to the cause, because sometimes in a mediation, you don't have control of your client. Your clients are maybe reading too many billboards and believing their case is worth 2 or 3 times what the lawyer says it's worth. So I meet with plaintiffs and plaintiffs' lawyers ahead of time too. It's important to do that in the right case, in the case where you're asked to do it. I can't force you, but it's certainly helpful. It's a really good point. I was about to talk about the broker in this case and get your input on that, because that may drive settlement value one way or the other. And we're in Florida, all of us are in Florida, and it's treated a certain way in Florida, and it may be treated a different way in a different state. So my understanding is in the 11th and 7th circuits, preemption is the role. In the 6th and 9th circuits, you can still make the claims against the brokers without the preemption argument foreclosing you. The agency argument exists, but there's lots of defenses to it. But the broker claim in this case could be something important for us to talk about ahead of time with the plaintiff and then with the defense. But Joe, tell us a little bit about how you handle that and what you would do to prepare for mediation
Yeah, I
beforehand.
mean, thank you for the lead in, John. You know, I mean, I do these broker claims all over the country. What's interesting is in the 7th, there's been now a state appellate case out of Illinois that said no preemption, even though in federal court there's preemption. And in the 11th now in Florida, our case, Simone versus Cutter Logistics, where the lower court, or one of the few times we've lost summary judgment on preemption, the appellate court said no. So the law in Florida, even though the 11th Circuit and federal is preemption, is that there's no preemption. But all of it's on hold because the United States Supreme Court is about to hear Montgomery, well, has already been briefed and had oral argument in Montgomery versus C.H. Robinson. And a decision on that is expected by the July 4th break. So we should have an answer. But in this case, I mean, we're handling these cases right now. The law in Florida is no preemption. There's no other dissenting opinion from there. So we would be pushing that case to get, to mediation if we could before June.
Yeah, you'd want to have that, and that's our fact pattern, by the way. We're on the eve of trial,
Yep.
motions in limine, motions for summary judgment, and we're mediating the case. And so everybody's got reasons for concern, right? So Dan, on that same topic, what would you be pushing for in advance of mediation on the
Well,
brokerage?
I'm not a big fan of the broker claims, although the plaintiffs love them because, it gets to bring in all this otherwise irrelevant evidence. That I think so. Maybe
I
not
think
everybody.
Dan's last name is Clooney.
Yes, I love Clooney. Clooney was the right decision.
No.
So what people on the phone don't understand is, the broker hires the truck, the motor carrier actually causes the accident, not the broker, right? So this is a passive way to go after somebody saying negligent selection of a bad driver. And I think, if we look at common law principles at home, you can't get sued for negligent entrustment unless you give the keys to someone drunk. And we're not talking about drunk drivers out there. So I'm a big advocate for the brokers, and I hope preemption holds up. But these are tough situations because a lot of my broker claims, if I represent the motor carrier, I've got I might have a carrier that wants to pitch their primary, but the insured needs a release from the broker. The broker's not giving up anything. The broker's gonna want to get released. And I don't know how much money the broker is going to want to deal with all of these preemption issues, getting teed up right now, and they're finally going to get decided. So at the end of the day, I think that you need to have good communications with your broker's counsel. And personally, I'm a big believer in first having a defense attorney only call and then a Tower of Terror call, meaning you get all the insurers on as well, and you try to iron out these issues because it's not that different. But the big difference, the reason we say trucking cases are so more dangerous is in Florida, if your spouse ran 5 stop signs in the last 5 months and ran a stop sign and killed someone today, those 5 stop sign violations in the last 5 months are not going to be admissible. In trucking, they're not only admissible, everything about them is admissible. So it's, everything that a motor carrier and its drivers have done with respect to the qualifications of the driver, the history of the driver, the employment background of the driver, the personnel file of the driver, everything that has been done becomes fair game with respect to whether the broker engaged in negligently an independent contractor to do that shipping. And so we need to have them involved because they do have exposure. If the case goes the other way, it's kind of an all or nothing case. If preemption holds, then brokers can just say, we're out. We pay nothing ever again, right? I don't know how you feel about that, Joe, whether that's the case, but
Our roads are dangerous enough, Dan. Could you imagine if nobody's responsible? They don't even have to hire motor carriers with a license. Free kill. It's a free kill bill.
it's a free kill bill. Well, that's why we have Congress, right? But at the end of the day, if the broker liability is extinguished, that is going to impact these cases. I think it's going to make these cases easier to settle and less complicated to settle, because you don't got to get the broker out. To me, it's not much different than when GMAC leases your car for 3 years to you. GMAC's not the owner of the vehicle. They're not on the hook if you cause that accident. So you don't got to get a release for GMAC. You don't got to worry about GMAC. GMAC's never going to get sued. The brokers could go that way if that broker liability hits. But up till now, I'd be calling Rod to set the mediation and tell him if he says he has anything before September, I'll never use him again. No, I'm joking.
Good. So you're going to want to, my belief is you're going to want to get the broker to toss something in if it's valuable.
Of course.
To get the case resolved, even though you believe strongly that the broker shouldn't be involved. But we're on the eve of that decision coming down from the Supreme Court, and we're going to get tried before that. So to cut losses, if your XYZ is willing to dump their limits, all of their limits, you want to get the broker out too, and get them to toss in some money too, right? So you're advocating for settlement ahead of mediation.
Yeah, a closed claim number is a good claim number. And if it ain't closed, you may be dragged back in. So yes.
Right. So that's where that brings us to basically the next phase, which is when you mediate the case. Joe, you're going to take the position this is all the fault of the truck. You're going to tell us about your opening statement, regardless of whether you believe you're going to win on those issues. Tell us about your opening statement. What are you going to harp on?
Well, I've become a fan of not very detailed opening statements. I used to do like big PowerPoints, and I just see everybody getting pissed off, and you're giving them stuff to fight about, John. So, and a lot of lawyers disagree with me on this. So generally, I'm going to reach out to Dan and say, do your people need to see me do an opening statement? If not, I'm going to just hit the highlights. Look, I know disputed liability. We have a tough job to do here. For us to get the case resolved, we got to take a lot less than we want. For you to get the case resolved, you got to pay a lot more than you want. You probably valued this case just based on the injuries in the beginning, not based on the complexities of the case or who we are or potential trial risks. So I don't know what your reserves were in the beginning, but we all have a job to do today, and we're here, and we're here and open and trying to get it done. And we're always hopeful, but maybe not optimistic, and we're here to listen. Is how I would approach this in the opening. I don't want to piss anybody off. I want them to know I'm here to try and get the case done. But part of what you were just saying, John, given where we are right now, I would be reminding, I'd wait for the defense to either make a response or not, either in opening or in the first moves. But my message would be very simple, right? Montgomery is going to rule on the negligent selection of a broker claim. We have agency and statutory employer in this case. That's not going to be resolved by Montgomery. So although that comes out, we still have the other ways we can get to the broker money. And a lot of times even beyond that, the policies provide coverage, even if you just look at the policies as an additional insured or omnibus insured. So there's a lot of different ways to get to those policies. And, given the fact that's an appeal coming and all that, we're willing to negotiate today at a more reasonable value than without the uncertainty of that decision coming down the pipe. So I would let them know that we're here at a compromised value, and that if you're waiting for after that, our number's going up, maybe double once it comes back in our favor, right? I mean, and once you understand we're going past summary judgment now, because you only get, even if that comes back favorable, you only get F4A preemption. You're still in this fight. You're still dealing with me in this case. So
Okay, that's good points. Dan, you going into mediation, what position are you going to espouse in the opening statement?
So this is first of all, it's a hot topic right now as to whether we're doing in-persons on these and whether we're doing opening statements on these. And I'll add a second component. I like doing opening statements. Okay. I don't know that in person is as important, but surprisingly, I'm seeing a lot of tower insurers want to do in person. They think that, it does provide more of an advantage. But in terms of openings, I like the openings. Now, if I think that it's going to be opening gone wild, then I may suggest to the plaintiff counsel, have your client step out for the opening so that you don't get them juiced, if I know them well enough. But I like the opening because here's the problem with trucking cases to my colleagues. There's what you think you know about liability and the regs. There's what you do know about reg violations. There's what you don't know about reg violations. And then there's what Joe knows about reg violation. And none of them are the same. So you need to, if you're not going to settle a case, you need to come out with some recon. What would it take to settle and how they're going to try this case? And I need to know what Joe knows about the regs. And the best way to do that at 110 words per minute, I type, best course I ever took in middle school. I take some detailed notes on Joe's position. And that's going to help me kind of go back on a post mediation if I don't get it settled and reassess it. So my strategy is you do the opening, you hear them out, and then you've got to address those points with Joe. And at the end of the day, I think they're important because look, let's be realistic. 90% of the regs Joe will say were violated did not cause the guy to be doing 25 and a 70, had nothing to do with it. Okay. Had nothing to do with why the accident happened, but they like violations of regs because that's got Reptile 101 all over it. These regulations and safety rules there to protect the public from big bad trucks. And when you violate rules, you endanger society. And ladies and gentlemen, you have to protect society. So I think it's important that we do those openings, and I think it's important that we flush out those issues. If that answers the question, John.
Good, yeah, good answer from both of you. Now, so we're in the mediation process now, and we're talking about strengths and weaknesses of your cases from both perspectives. Because if you're there believing in your own music, your own sheet of music, and nobody can move you, then the mediation's a waste of time anyway, right? So it's risk allocation and the discussion from the mediator, not to push too hard, but to talk about the issues is important because it brings reality into focus with the plaintiff and also with the defendant. And in this case, there's multiple defendants and there's multiple carriers involved, and they all have to be on the same sheet of music or we'll never get the case resolved. So from a mediator's perspective, I talked to the plaintiff about what I think are strengths and weaknesses of their case. After I've heard Joe tell me how strong his case is, I have to sort of poke holes in that. But I've got to do that in a nice way, or Joe never hires me again as a mediator. Number one, you have to be mindful that you're not there to make people mad. You're there to help them understand the risk, which is important, I think. So in this case, Joe's got a case where his client runs into the back of a truck. What are the issues? Well, Should he have seen it ahead of time? Should he have been able to avoid it ahead of time? Rear-end collisions are usually presumed negligence on the part of the driver in Florida. How do you get around that? Maybe this truck didn't have its lights on. Maybe the truck didn't have enough conspicuity tape on the back where it could be seen easily. There's all sorts of arguments, I suppose, that would be made. In this case, Joe's going to be hounding and pounding his fist on the table about the fact that this truck's going 25 miles an hour and the trucker said 60. But you can't, once the trucker's testified and said he's going 60, you can't erase that. You can't unsee it, so he's gonna look for a nuclear verdict because he's gonna try to make the jury mad at the trucking company because the guy's testified untruthfully. Now, there are some arguments you can make to the GPS testing, the EDR data and the GPS data, that it wasn't scientifically valid or what have you, but that's probably not going to carry the day most of the time. So the jury's going to believe this truck's going 25. Now, why is it going 25? We don't know that in the fact pattern specifically, but it does show, the EDR data does show that it was off the road just before this happens. And a reasonable conclusion is he's pulling out on the highway without checking his mirrors and paying attention, and he's not up to speed before he pulls out in that lane. He claims there's no lights on the car, so he couldn't see it. So that's his defense. But I've got to bring all those issues up as Joe's discussing them with me, because the jury could decide that he pulled out on the road with his lights on and that he was getting back into the traffic. The plaintiff didn't have their lights on and they ran into the back of him because they weren't paying attention. So I have to give him reason for thought, cause to be concerned. Also got to talk to him about the broker situation and the way the law's written now and what jurisdiction we're in and the uncertainty of what's going to happen with a Supreme Court decision. And all of those things may come into play, and the issue of whether or not you're gonna win against the broker, regardless of those defenses. What did they do wrong? The argument exists that we send stuff out every day with carriers. We deliver goods as individuals to people every day in foreign places. And are we responsible for the trucking company that's delivering it? Are we responsible for Amazon? Are we responsible for FedEx and checking every driver's history? Well, would a broker be responsible for that too? Those are things that jurors can latch on to as well. So I'm going to do everything I can in talking to Joe to show the risk that he may not win at all. If he does win, he may not get as much money as he thinks he's going to get. Because if he only gets XYZ trucking company, there's $10 million available if he doesn't get the broker, right? And what if his client is 51% responsible, the driver? If he's 51% responsible in Florida, Dan's going to win as to the driver, right? And if there's 51% responsible as to the driver, the passenger's claim, who's the decedent, is going to be decreased in value and maybe won't be as much as the underlying limits. So Dan's got arguments to pay less than the $10 million in coverage, perhaps. So all those things are things that I would point out and discuss in a polite way with Joe, and let him talk with me in front of his clients or behind the scenes about those risks. And hopefully that has some impact if I deliver the message correctly on his side of the case. And as to Dan, I'm going to go in there and do the same thing. I'm going to play devil's advocate and say, you've got a trucker that lied about the speed, lied about, the issue of going 60 miles an hour in all likelihood, and that could cause you real problems down the road. And despite what might happen with the broker, you could have a situation, or your excess carriers could have a situation where they pay a heck of a lot more than the value of the claim if they stand on principle. And maybe this is a case where you get a nuclear verdict that's just against XYZ trucking company because of the scenario where he tells a story, or likely tells a story about his speed. There's all sorts of things that could come into play. I don't know what this truck has in terms of lighting. I don't know what it has in terms of conspicuity tape. I don't know how easy it is to see. I don't know the reason he pulled over for a little while. Don't know the reason he's pulling out in the highway. If he's right though, if he's believed on the fact that the lights aren't on in the car that runs into him, then Dan has a pretty good argument, right? If the lights aren't on, he's pulling off to the side of the road. He doesn't see anybody, and he's pulling into the lanes of travel. And so there is a opportunity for Dan to argue that there's no liability. So there's good and bad in both rooms. I'm tasked with the ability of talking to them about the things that they don't like to hear, in hopes that somebody in their room will listen to the mediator and evaluate the risks rather than getting stuck in a position. So those are the kinds of things the mediator can do during the mediation. Talk about brackets if they're necessary. Those are also tools to use. Sometimes it comes down to ultimately the parties wanting a mediator proposal. And that sometimes is helpful once the case gets to a stall point and trying to get more movement or trying to get a settlement to occur. So those are things the mediator might do in the mediation process to help bring the case to a conclusion. So let's talk about the damages issues if we can for a moment. Joe, tell us a little bit about what damages issues you see in this case and how you would approach them during mediation.
Well, I mean, you have a death, and then you have a serious injury case. And, we didn't build a ton of facts into the fact pattern about what those, other than what the plaintiff contends the values are. Because of the fact pattern, it's just the death claim 20 to 40 and the injury claim 25 to 35. You know that it's you can assume that it's probably a surviving spouse and kids, and you can assume on the other side that it's a significant injury with either doesn't have memories by TBI and orthopedic injuries in a big crash like this. So, there's lots of different ways to do that. I'd be curious what the defense perspective is. Unless I have like a paraplegic or something, I'm really not going to do a day in the life video, that kind of stuff very often. Sometimes my co-counsel really wants to do that. I'm not a big fan of that. What I do like to do is either through just an agreement, informal discussion, or mediation after the key depositions of the before and after witnesses have been taken, is you let the defense or talk to the people that are going to be talking at trial, so they have that intel. I have been accused, probably Dan will tell you this, of having a very bright view of the damages in my clients' cases. But it's because we walk a mile in their shoes, right? We say all the time, I tell my team, if you're doing these cases correctly, these catastrophic trucking cases, most of them death, each one takes a little piece of your soul with you, because we love our clients. We spend time with them, grieving, laughing, crying. We're in their homes, they're in ours. We spend a lot of time together. And so our job is to, when we know the clients and the cases that well, it's hard to not see the full value of those cases, to not imagine that. And, so we try and share those damage stories in ways that make sense without offending people. But oftentimes the defense is just seeing, okay, this is a death case. A death case isn't worth more than blah, from some historical number that they came in when Dan and I started practicing law, when Jesus was walking the earth still, right? Like, we're old guys. I remember when I started as a defense lawyer, the death case was $1 million, right? I'm not sure there is a death case worth $1 million anymore. It would be a very, very, very bad case. But so from my perspective, it's trying to be open to that and understand that there's different opinions of value, and I'm not offended by that, right? I want to try this case. I don't want to settle this case. My job is to settle this case if we can. So, if we have significantly different disagreements on value, thank you. We get to try this one. Let's see who's right, who's wrong. Let's see what a jury does with it. Dan didn't make his reputation. I didn't make my reputation settling all of our cases. We settle the cases because people know what he can do at trial and what we can do at trial, and that we're both crazy enough to go do it. So, for me, I don't want to offend people with my numbers. I'm going to be passionate about it. I'm going to tell you why I believe. And I always tell my clients, listen to every word the defense says. You're not going to agree with it. have a poker face. Don't let it upset you. But what you need to understand, I want you to think that everything they're saying, just like Dan said, they're going to have evidence of that at trial. So you need to put yourself in the shoes of a juror if you can and understand this is what they're going to tell a jury, not just what they're saying to you here. So I think it's important to listen to both sides. And then, on our side, we're evaluating risk in a financial analysis type way. Just I think a different but similar analysis to what the defense is doing in trying to find out, what the hate number, right? The number that everybody hates, the number that's not what anybody wants to pay on the defense side. It's too high, but not too high to avoid risk of trial. On the plaintiff side, it's nowhere near the money they want, but it's not too low that they can avoid the risk of trial. It's the hate number.
Okay.
And so
So the driver, with regard to your driver's side of the claim, this one, not the death side, but on the driver's side, it says it's a pretty serious injury. So in those cases, you have life care plans and whatnot that you present.
Depending on the facts of the case, but yeah, we want to try and have that all done in advance of the mediation if it's possible. It's not always possible. We're actually working a very, very big case against a national motor carrier, motorcycle versus tractor trailer crash case where our guy's got a TBI and big physical injuries. They want to mediate early, and our life care planner just told us it's going to be probably 18 months before I can answer these questions. So you can't always do that, but we definitely want to, the more information, data points I can give Dan and the mediator, Dan before mediation, and then you have it at the mediation, the more things that they can document on their side to say it's not just some lawyer saying something. They have evidence for it. Here's the economics, right?
Perfect. Well, that helps. An economist report, if you have it, that's always helpful. Dan, those things obviously important to you to have well in advance of mediation.
Yeah, a lot of times we get them the day before, which isn't very helpful. But look, at the end of the day, the more information the defense can have, the better we can evaluate the case. We do something called a pre-mediation report, and it isn't done the day before the mediation. It's usually done 30 days before. So we need that information because here's what we have to live with. If we pick a range or we pick a number that we think is reasonable and we're wrong, we've got to backpedal on that. And that's a difficult thing to do because based upon our evaluation, the claims professional will set a reserve. And if that reserve is under reserved, it's a lot of work to go back and try to fix it. So it's not good. It may feel good for a plaintiff attorney to walk in and sandbag us with a bunch of new information. It's not going to help the process at all. I'll tell you this much. There's no exact science to evaluating the settlement value on a case. It's a little bit of what do you think the reasonable value is versus what do you think it would take to settle the case? It's somewhere between there. And 10 juries will give 10 different numbers. The other thing is you've got to consider reptile versus comparative fault. The same injury, whether it's a death, TBI, whatever, has a different value if there was significant comparative fault than if there was significant aggravating liability. That's just the reality of it. The same injury has a different value because even though the juries are told, don't make any reduction of fault, the court will do so in entering final judgment, they're going to give less for people that are stupid. And they're going to, well, they are. And they're going to,
I agree.
They're going to give more for companies that put profits over safety. So at the end of the day, what I want to know, and I see all these per diem arguments made, $10 per day for pain and suffering. Look, I have very few goals in life. I've achieved a lot. One of them is to eliminate per diem in Florida forever. Okay. I don't think it belongs in the state of Florida. It's a golden rule violation, but I want to look at that and I want to be able to try to establish what the reasonable value is. So I'm mediating 3 cases. I'm mediating it with you, John, because I don't want you to know where I'm really at. You're not going to help me if you know where I'm really at because your goal is to settle the case. My goal is to get the best number. we don't have the same goals. So I don't need you to know what my best number is. I'm mediating with the plaintiff attorney, but I'm also mediating with my client because I've got to get them into the same thought processes that I have as to what I think the sheet of music looks like, as you like to call it. But at the end of the day, I also have to mediate against the plaintiff. If I can't get through to Joe, I got to try to get through to Joe's client. I got to give him or her something to think about when they go home for the weekend and Joe's working on his next case and they're sitting there just thinking, when am I going to get my money? So every move I make is a new message. Okay. The first move in messaging might be if you get hit for over 50%, you get nada. The second move in messaging might be that, we've got a difference in opinion on the value of this case. The third move that, I might make, or the third messaging I might make is to show them the value of money. You could structure this. It's tax-free for life. We're trying to protect you. We're on your side. The fourth messaging move might be interest rates are good right now. You can't do this little structure that protects you if you try this case or wait another year. The fifth messaging move I might make is we got a lot of appellate issues. You just heard we don't agree on a lot. You know what appellate means? Appellate means we might retry this case in 2031 and you might get paid in 2033, or you could get it next week. Think about it. So these are all the strategies I think that go into what the value of the case is. And at the end of the day, Joe says he looks for the hate number. I look for the break number. And I kind of know by the time I'm done with a mediation, I don't care who it is, how good they are. I kind of know what they want. And I kind of know what they'll take. The question is, where do they break? And I'll add one more component here that I think a lot of people don't look at. I look at analytics. So I have analytics on Joe. I know what he settles on the dollar from his demands and his opening and mediation. And I have it for most attorneys. It's just for my law firm. But those analytics are important to me. If Joe generally settles for 18 cents on the dollar, it's not rocket science to know that that's just kind of his brain makeup on how he likes to settle. And Joe, I'm not going to tell you what you settle for on the dollar.
Now I want to know. I want to know my analytics.
But analytics are just another factor because, again, at the end of the day, you're trying to get a confirmation of that break number, what it will really, where the case really breaks down and settles. And when you start to see those confirmations line up, then you start to realize that you have a pretty good shot. So
what you've just described for me, Dan, is perfect information to end this mediation seminar or webinar, and that is if Joe's client has all the information in bits and pieces that you've laid out and gets to sit and think about a number that you've already offered or a structure that you've already offered, then there's an opportunity for the mediator to do work beyond the mediation itself. If it doesn't settle, but you've given the mediator all the tools that you just described, that I can then work with Joe and Joe's client on those principles if the occasion arises for that to happen, then the case can settle after mediation. And it is our job as the mediators to pick up the ball after the case is over, after the mediation is over rather, and reach out to the lawyers and see if there's reason for compromise or further discussion.
yeah, I mean, John, it's not just that. You're bringing in every message I have, and if you don't deliver it well, you're not going to help get the case settled.
That's
So
right.
the mediator's critical. If you're just the Uber Eats guy, it's less likely we're going to get the case settled. If you're just dropping off messages.
No, you can't, as an effective mediator, you can't just deliver messages. You have to talk about the message and how it affects the outcome and could affect the outcome. And I appreciate the opportunity to discuss all these principles and issues with you and how to reach an effective settlement through mediation. This was I think, a great topic for discussion. I think that Dan and Joe, you did a terrific job of outlining how to succeed at mediation. If everybody has taken away from this webinar the kind of information that I have in listening to what you have to say. I think they're better for it. Bo, you want to wrap this up?
Yes, thank you all. In conclusion, as everyone has witnessed today, trucking cases are complex to mediate. Given the multiple parties, layered insurance coverage, law, and the high stakes involved with these cases, and you can have a nuclear type of verdict because of these cases, and they're difficult to mediate. I just want to thank everybody for attending today, and we might continue on with this subject matter because we weren't able to handle all the issues involved in trucking cases. It's something that we might have to continue in the future. Thank everyone for attending, and I appreciate Joe, Dan, for helping us out. You all did a great job.
Our
Thank
pleasure.
you.
Thank you for
Great
having
job.
us.
Take care, guys. Joe, see you on the next one.
Yes,
Okay,
sir, you
here's
will.
your CLE numbers. If you are a Florida attorney, please jot down the Florida Bar course number so you can post your CLE credit online. It is 2603118N. That's 2603118N as in Nancy. Credit is also available in Alabama, Illinois, and Tennessee, as well as Florida Adjuster CEU. Please see your follow-up email on Friday for more information. We're building our webinar schedule for the coming months, and next we'll have a CLE program from our Center for National Class and Mass Actions on May 29th. Please watch your email inbox for news about our future programs. On this slide, you'll see contact information for our presenters and technical assistants. Sign off for the presenters. Thank you, guys. I appreciate it.
God
Thank
bless.
you, Kathy.
Bye-bye.